In a rare and contentious move, federal authorities arrested Milwaukee Circuit Court Judge Hannah C. Dugan on charges of obstruction of an immigration enforcement operation, raising urgent questions about the balance of power between state judiciaries and the federal executive. The incident, which unfolded on April 18, 2025, has reverberated through legal and immigrant communities, igniting debate over the proper role of ICE, immigration and customs enforcement, within state courthouses, and the potential chilling effect on vulnerable populations seeking justice. Hannah C. Dugan's legal career spans decades of advocacy and public service. Beginning as a staff attorney with legal aid, she later joined Catholic Charities to represent disenfranchised clients. In 20 Roman Tathy, she was elected to the Milwaukee Circuit Court bench, where she has presided over civil and criminal matters for several years. Judge Dugan earned a reputation for fairness, integrity, and a measured approach to courtroom administration, particularly in cases involving domestic violence and immigration interfaces. On April 18, federal agents from ICE designated Eduardo Flores Ruiz, a Mexican national facing domestic violence charges, as their target for apprehension and removal. Rather than secure a judicially authorized warrant, ICE relied on an administrative warrant, a lower-level document that does not require a judge's endorsement and does not carry knock and enter authority. Agents positioned themselves inside the Milwaukee County Courthouse, intending to intercept Flores Ruiz immediately after his hearing in Courtroom 6-15 before Judge Dugan. During the hearing, Judge Dugan was notified of the agent's presence. She inquired courteously but firmly, "May I see your warrant?" Upon learning it was administrative rather than judicial, she directed the agents to obtain a proper court order and to discuss any courthouse entry policies with the chief judge. This response aligned with long-standing local practice. The Milwaukee County Chief Judge has prohibited ICE arrests within courtrooms and public corridors to prevent deterring litigants from attending scheduled proceedings. Once her session concluded, Judge Dugan escorted Flores Ruiz through the jury box and into a secondary public hallway, an alternative exit not monitored by ICE agents. By selecting this route, she ensured that Flores Ruiz could depart the courthouse without direct federal intervention, preserving the integrity of state court proceedings and minimizing disruption to other scheduled matters. In retaliation, federal authorities swiftly filed a criminal complaint against Judge Dugan, accusing her of intentionally misdirecting agents and obstructing an immigration arrest operation. A senior ICE official announced via social media that evidence of Judge Dugan obstructing an immigration arrest operation justified her arrest by the FBI. Flores Ruiz himself was apprehended moments later outside the building and remains in federal custody. Unlike an indictment issued by a grand jury, the criminal complaint relied solely on an agent's affidavit. Judge Dugan was arrested, booked, and released on her own recognizance without bond. Under federal procedure, prosecutors now face the choice of presenting charges to a grand jury, a step required to convert the complaint into an indictment, or dismissing the case if they determine probable cause is insufficient. Legal experts warn that the use of administrative ICE warrants in courthouses undermines established sanctuary protocols and may deter undocumented individuals from participating in criminal and civil court processes. If non-citizen victims or witnesses fear federal arrest at the courthouse, they may forego reporting crimes or testifying, compromising public safety and the equitable administration of justice. Moreover, the arrest of a sitting state judge raises alarms about judicial independence. By targeting Judge Dugan for adhering to local policy and insisting on proper judicial authorization, federal authorities appear to challenge the autonomy of state court operations. A similar event occurred in 2017, when another state judge was arrested under comparable circumstances and ultimately resolved the matter through judicial ethics proceedings rather than criminal trial. This episode fits a broader pattern of aggressive federal enforcement tactics under the Trump administration, characterized by surprise arrests in sensitive locations, churches, funerals, schools, and a willingness to confront local officials who resist. Critics contend these measures represent executive overreach, threatening the separation of powers and the rule of law. As Judge Dugan prepares her defense, having retained a former federal prosecutor, observers will watch whether prosecutors secure a grand jury indictment or allow the charges to lapse. The outcome will have lasting implications for the interaction between immigration enforcement and state judiciary procedures, the protection of court-dependent communities, and the preservation of judicial independence against political pressure. In the weeks ahead, the legal community and affected populations will measure not only the merits of the obstruction charge against Judge Dugan, but also the broader message sent by federal authorities. At stake is the principle that courts must remain accessible and impartial sanctuaries for all who seek justice, free from intimidation by external agencies. Building on the preceding analysis, further examination reveals deeper constitutional, procedural, and community dimensions. Judge Dugan's insistence on a judicial warrant highlights the Fourth Amendment's protection against unreasonable seizures. Notes: administrative ICE warrants do not require probable cause determined by a neutral magistrate, nor do they carry statutory knock and announce authority. By demanding a court-issued warrant, Dugan underscored the necessity of judicial oversight in any detention, ensuring that executive action remains subject to checks and balances. This insistence not only complied with federal rulemaking around civil immigration enforcement, but also affirmed the judiciary's gatekeeping role in safeguarding individual liberties. Milwaukee County's long-standing policy prohibiting ICE arrests within courthouses, and similarly in churches, schools, and hospital grounds, reflects a deliberate effort to preserve sanctuary spaces for all litigants. Adopted by the County Board of Supervisors in 2020, the directive aimed to prevent the chilling effect on crime victims and witnesses who might otherwise forego legal recourse. Judge Dugan's reliance on this policy aligns with uniform local practice. It ensures that individuals with urgent civil or criminal matters can navigate the justice system without fear of collateral immigration enforcement. The reaction among public officials and advocacy groups has underscored the case's high stakes. Governor Tony Evers publicly criticized the federal operation as an overreach that jeopardizes both public safety and judicial integrity, echoing concerns voiced by the AZ Wisconsin chapter. Immigrant rights organizations have decried the arrest as a tactic to intimidate local governments into cooperation, warning that the broader immigrant community may retreat from court participation, thereby undermining rule of law objectives and straining prosecutorial efforts to hold violent offenders to account. Academic commentators have likewise weighed in. Professor Laura Gomez of the University of Wisconsin Law School describes the arrest as of the most significant federal encroachment on state judicial autonomy in recent memory. Noting parallels in other jurisdictions where similar confrontations led to protracted litigation over federalism, boundaries, separation of powers experts caution that permitting the executive branch to unilaterally challenge state court policies through criminal charges against sitting judges could create a precedent enabling political targeting of judicial officers who apply local rules. Against this backdrop, Judge Dugan's legal team is preparing a multifaceted defense. They are expected to file a motion to dismiss under Federal Rule of Criminal Procedure 12b-3. Arguing that a complaint based solely on an affidavit lacks the requisite probable cause. Simultaneously, they may invoke qualified immunity, contending that Dugan's actions, consistent with published court policy, were both reasonable and lawful. Should the case proceed to a grand jury, her attorneys will likely introduce evidence of her courtroom management record and community service to demonstrate the absence of willful obstruction. Looking ahead, several scenarios emerge. If prosecutors advance to a grand jury, the ruling will signal whether the Justice Department is willing to escalate this confrontation. Conversely, a voluntary dismissal or ethics referral, akin to the 2017 precedent, could affirm the judiciary's prerogative to regulate its own proceedings without criminal intervention. Regardless of the outcome, the arrest has already sent ripples through state-federal relations, prompting other jurisdictions to re-examine their sanctuary policies and spurring debate over the permissible scope of immigration enforcement within local court systems. Ultimately, Judge Dugan's case stands at the intersection of civil liberties, immigrant access to justice, and the separation of powers. Its resolution will shape not only her career, but also the contours of federal authority over state court operations, determining whether courthouses nationwide remain accessible sanctuaries or become arenas of executive enforcement.